Hi, welcome back to the Hill Law Group Legacy Building Podcast. I'm Meredith Hill.
And I'm Ericca Pearson.
And today we are going to be talking about planning for incapacity, and what exactly incapacity means and how we can make arrangements to have our affairs in order. So it'll be an enlightening conversation.
Yes. Yes. So lots of times we put together your trust or your estate plan, really, and many people are thinking that these documents will be in effect when you pass away. But lots of times there are instances where your estate planning documents function very well when you are incapacitated. And that means if you are suffering from some form of dementia. So I think all of us have a loved one that may be suffering from Alzheimer's or different forms of dementia, where it kind of gradually becomes a problem. So maybe in January, your loved one is perfectly fine, and then things start slipping throughout the year. And by the time December rolls around, they are in a place where they're declined and they are not able to take care of their financial affairs. They may not be able to take care of themselves. And just during the course of that year, they may need some documentation to assist you as their loved one in handling retirement affairs, and really calling the cell phone service to make sure that either you can cut that service off. If you don't have power of attorney, which is a document that you should have in place for individuals to handle your finances if ever you become incapacitated. Healthcare powers of attorney, very important for individuals who are incapacitated. And your trust document could function very well in that instance, basically giving your trustees, people who you trust literally, to take care of you from soup to nuts. Making sure your bills are paid, making sure that you are go to your doctor's appointments. So estate planning documents function very well during those times of incapacity, as sometimes even more so than when you pass away, because I think the certainty is that we know all of us are going to pass away, but we don't know if we are ever going to suffer from incapacity, and don't know when that's going to happen.
Mm-hmm. And something that's important to know that you mentioned is that you may get a diagnosis of something in January, and then by March you might be incapacitated. And so things can happen very, very quickly. And a lot of times you might not have the time to get your affairs in order and to nominate a power of attorney, get the document drafted in time and signed and notarized. So it's important that when you are thinking about planning for incapacity, you are thinking about planning while you are still healthy and of sound mind. So we write these documents while you have capacity,
Mm-hmm.
and you know what you're doing, and we're hoping that you'll never have to use it.
Yeah.
But just in case you need to, you have it there so that your family is not scrambling trying to figure out what to do and when to do it. And so that is like very, very helpful. So we've dealt with clients, we deal with a lot of clients, but we've had clients in particular that come to us, or potential clients that try to come to us to help with planning for a power of attorney or a guardianship. And unfortunately, it's too late at that point because the person is not of sound mind. They don't know their own name, what day it is, their relatives, and it can just happen very quickly.
Mm-hmm.
It's also not just mental incapacity, but also like physically, you just can't be there.
Mm-hmm.
And you need someone to step into your shoes and act on your behalf. So recently, and I'm hoping that she's not going to get upset that we're sharing the story, but our dear paralegal had a family member that went into the hospital
Mm-hmm.
and needed some of his affairs taken care of, and wanted our paralegal to do it. And unfortunately, there was no power of attorney in place, and so nothing could get done. And it was a very frustrating time for her family, Fortunately, he recovered and he's fine and healthy now, but he now has a power of attorney. And so it's good. And so that's not sometimes like he's fortunate to have that, to come back from it
Absolutely.
and have that scare and realize like, okay, this can really happen. But a lot of times people are not that fortunate.
And I think lots of times we don't think about life being really fragile. Like things can turn on the drop of a dime. We get into cars very confidently, and there are people, somebody today that got in an accident that may have changed their life. You can have accidents in your home that change your life. So really, you want to plan for things when you are healthy, when things are going well. Because the one thing we can't do is we can't predict the future. We can't predict how these things are going to play out. And lots of times when we're talking about estate planning documents, we talked about power of attorney, healthcare power of attorney, your will, or, your trust. I can't really tell you which of these documents is going to be the most valuable to you in your situation because we just don't know what is going to happen. Lots of times, the trust will be the most important because let's say a married couple passed away at the same time and had minor children. Well, then that's going to be the most important. But if you have an elderly parent that was doing fine 5 months ago and is not doing fine now, then that power of attorney and your healthcare power of attorney seems more valuable at that time than the trust. So, it's all of these documents are very important to estate planning, and each of them, based on the scenarios, will be very important to you. And so one of the things that we like to do is, again, plan when everything is okay. I know I've said that several times, but I can't say it enough. And to just make sure that you kind of have these documents in your safe, set aside for when things go wrong. We want to make sure that you're taken care of so that there are lots of things to worry about in life. I want to take that portion off of your plate to worry about, to know that if anything is going to happen to me, whether it be incapacity or death, that we're covered. And then I guess get on to the business of worrying about those other things that can happen in life.
So I think it would be beneficial, Ericca, if we went through and talked about just a little bit about each document that helps with planning for incapacity.
Okay.
So the first one that you've heard us mention a lot is the power of attorney. And this is a document that you create when you are of sound mind and you know what's happening. And it allows you to nominate someone to step into your shoes and act on your behalf if you are physically or mentally unable to do so. They're able to handle your finances for you. They're able to, depending on how thorough the power of attorney is, they can update documents for you. They can pay your rent. They can sue on your behalf if
They
needed.
can call and check on benefits.
They can call and check on benefits. They can do a lot of things. They essentially are becoming you. And so that's number one. One thing to note about this document, or a couple things. First, there's a big misconception that this document also goes into death as well. And the person that is named on your power of attorney is also going to be the executor or personal representative of your estate. And that is not accurate. This document is only valid while you are still alive. Second, this document, you can name joint power of attorneys. I strongly recommend not doing that because it just can complicate things. And when you're trying to use it, you'll need both people to be present and sign off on everything. And that can just make things very complex. Yeah, very complex and challenging. And then you can make it effective as soon as you sign the document. So as soon as you sign it, it's witnessed and it's notarized. Whoever you name in the document can immediately start acting on your behalf. If that makes you uncomfortable, then we can make it so that it only becomes effective at certain events. Usually it's when like a doctor or two doctors say that you are incapacitated and your power of attorney needs to step in. Usually we draft hours as so that they're effective as soon as they're signed, just to make things easier. But it really is up to the client and what their comfort level is. And most importantly about power of attorney documents is make sure you pick someone that you trust. That you trust. Because you don't want to pick someone just because they're your spouse. Hopefully
Or
you
your
trust your spouse.
firstborn,
Or your firstborn. Or because they're your best friend, but they're not very good with money or anything like that. That's not the person. You really want to try and make sure that this person's going to, you can trust them. They're going to take it seriously and they won't abuse the powers.
Absolutely. Absolutely. Then the next document that we include is your healthcare power of attorney. Healthcare power of attorney functions very similarly to the financial power of attorney, except the healthcare power of attorney deals with making healthcare decisions on your behalf. Again, this is a document that functions while you're alive. So if you are unable to communicate, you are in a coma, you've slipped into a coma, and you are not able to indicate whether you need surgery, whether you need to make whatever types of decisions that need to be made after you are in this coma. Again, I think it definitely needs to be someone who you can trust, someone who really has kind of the personality or the ability to deal with medical issues. And I think you'll be able to kind of gauge that with the individuals in your life. To know that there are some people that may get very emotional about making healthcare decisions, or maybe that's just not their thing. I think you should choose someone, if you know somebody who's in the medical field who may have knowledge, a nurse. My medical power of attorney is a nurse, and she's a very good friend of mine. And some of the decisions that I have, she necessarily would not have made them. But guess what? It's my estate plan. And so I think you should select the best person for making those types of decisions. So healthcare decisions, I think, are different from financial powers of attorney, where those people need to be kind of detail oriented, very much, if they handle their money well, they'll probably handle your money well. But then if there are people who are kind of have that type of, those people who handle things in the midst of a storm, are able to make sound decisions and the best decisions on your behalf, would serve well as the healthcare power of attorney. But again, you want that in place before anything happens, because things could change. If you're in the hospital, things could change from you being fine one day and then not being able to communicate. So you want to be sure that you have that healthcare power of attorney in place. And generally, we do all those at the same time. So
one thing to note about the healthcare power of attorney and the financial power of attorney is that the person you select does not have to be an attorney. That is another misconception. And people always ask if they have to name an attorney.
Absolutely not.
And that's not the case.
No.
Name whoever you want to name, as long as they're 18 and above, and take it seriously and you trust them. That's all you need for those positions.
And generally what I would say is most people either select their spouse or their children. And that, I would say a majority of our families, that's what happens. If you are married, you guys are each other's power of attorney, and then you list your children in whatever order that you would like. It does not necessarily have to go in order of age. You go in order of who's best able to deal with these scenarios. And I think that those are generally good people to select for these roles. But if your scenario that it's not, kind of think outside of that box. It doesn't even have to be anybody who is related to you. You can select individuals who are very, very good friends. Childhood friends can serve as your financial or healthcare power of attorney. It's really you making the best decision for you when in those situations when you won't be able to make that decision for yourself. So,
and then just quickly, the last one that I think we should talk about is if you have a trust. And again, not everyone will have a trust or need a trust really, but if you have a trust document, and we talk about trust in another episode, so look back at that one. The trust can really help with avoiding guardianship hearings if you are incapacitated. And so if you no longer have sound mind, or if you're in a coma, then whoever you've nominated as your successor trustee can step up and manage your affairs, as long as you have properly transferred them into your trust. And your attorney, your estate planning attorney, should be able to help you, guide you along with what needs to be transferred and how to transfer it. But a very big pro of having a trust is that you avoid a guardianship hearing altogether. And guardianship hearings, they occur when someone petitions the court and says that you are not capable of managing your own affairs.
So this is in an instance when you are incapacitated and you don't have any documents in place.
Yes, and you don't have any documents in place, and then they go to the court, and it's a whole court process, and then the court nominates someone to serve as guardian for you. And so this may be someone that you know, who you trust, but it can very often be someone that you don't even know, that you've never met before in your life, who may take advantage of the system. And we don't want for people, especially our clients, to ever be in that situation. So we try to make sure that we have them covered through either the trust document or the power of attorney in the healthcare directive, or a combination of all three.
And the guardianship proceeding is it's a very lengthy process. It is a very expensive process. So just think about if you ever become incapacitated, and there are these 3 to 6 months where nobody is taking care of your affairs because you can't. And they initiate this guardianship proceeding and it's taking a long time, and that it really kind of is leaving you out there caught with nobody to handle your affairs with the legal ability to handle all of your affairs. It can cause a lot of chaos, unnecessary chaos, that you could really just take care of with a pen stroke in putting together a proper estate plan. And it's very costly, more expensive than putting together the estate plan. Your guardianship proceeding, it can be very, very costly. And, where are those funds coming from? Who's handling all those things? So you've created a scenario where you haven't named anyone to do the very thing that they're having to do. So naming who's your power of attorney, who's your successor trustee, who's your healthcare power of attorney, is the thing that you have to do to make sure that all those things are taken care of. And so you don't have to go through that guardianship proceeding.
Well, Ericca, I think that we did a good job touching base on planning for incapacity. We could talk about this for a long time and tell you lots of stories, but we will spare you all of the details. But if you wanted to get more information about our firm, the Hill Law Group, you can go to our website, thehilllawgroup.com. We are estate planning attorneys based in Bethesda, Maryland, and we serve clients in Maryland, DC, and Virginia. And so with that, we will see you next time.
Next time.